In Florida, a last will and testament can be created rather easily and often without seeking legal advice from an expensive lawyer. Wills successfully document how an individual wishes to distribute their assets upon death, allowing for peace of mind that their loved ones will receive what's intended. This video will cover the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Florida, and how and where to create an official will. Let's begin. What are wills and why are they so important? A last will and testament, also simply known as will, is a document that communicates an individual's instructions on how to distribute their property among family, friends, and other beneficiaries after their death. It's highly recommended for all adults to have a will, especially those in the later stages of life. Now, what occurs if no will is left in Florida? A person who passes away without a will loses full control of who inherits their property. The state of Florida and its probate laws will dictate how the deceased property is handled. The assets are usually passed to the deceased spouse and/or any children. Even then, loved ones can unfortunately dispute about who is the rightful heir to certain property. One can avoid any uncertainty by making a clear will document, and often without an expensive attorney required. A person of sound mind can draft his or her will in Florida with the following essential information: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's look at some legal requirements in Florida. Last will and testaments in Florida must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 trusted witnesses. These 2 individuals must be considered competent, and though optional, it's also recommended that the witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. The will remains valid regardless if the witness stands to benefit from the will or not, but it's in good practice to use neutral parties to avoid suspicion. Once created and signed, the document will be legally binding. Multiple copies can be made and given to the executor of the will and any other trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We've created extensive last will and testament templates for Florida that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions. Click on the link below to begin creating your will now. And don't forget to like and subscribe for more daily videos.